Well, it's not a buildable lot.
Yes, and I don't know how they can separate parcels.
Well, I have to defend myself.
Yeah, and, but the flip side, I'm not arguing where you are, the flip side is with us, where we've been paying
For.
for the street as it is. Lakeland restoration.
So do you want to?
The frontage and the lot.
Okay. Did you?
No.
Don't see I'm doing that.
Oh, you got the road.
Are we in court?
I signed the land. Thank you.
If you plan to testify, that'd be good to sign in and check whether or not you're gonna testify.
I went.
You can testify. Because then I can tell how many people are gonna testify.
What's he saying?
You have me sign in if you're going to testify in that.
You already told me.
Yes, yes.
Does anyone wish to?
Okay, well, it's just past 1:30, so we'll slowly open up the hearing. Okay, so this is a hearing that we're opening to address the objections on the special assessment for the Lake Management District. Number one, your staff to introduce the hearing.
Thank you, Mr. Chairman. For your record, I'm Perry Huston, Director of Planning and Community Development for Okanagan County. Before you begin with the nuts and bolts of the hearing, some housekeeping we should engage in. I realize you have it electronically, but I would also give you copies, hard copies of the roll that was put out for public review, and that has been available for public review at a number of physical sites and on our website. In addition to that, I have a staff report which I prepared, which mostly lays out the procedural format, if you will, for our hearing today. While I have very little in terms of substantive information to offer, I may be called upon to respond to questions regarding the individual parcels. So with that, I would suggest you go ahead and place me under oath before I continue with my presentation. On page two of your staff report, first paragraph under procedure, there is the oath that we routinely employ when we enter into quasi-judicial process with the hearing examiner.
Please raise your right hand and state your name for the record.
Perry Huston, Director of Planning, Okanagan County.
Do you swear that all the testimony given in this hearing will be the truth under penalty of perjury?
Yes, I do. Very good, thank you. Commissioners, you are in a quasi-judicial proceeding. You are acting as a Board of Equalization, not the Board of Equalization, which is another appointed body with special authorities under the state law. But you are acting in that capacity today. So, before you proceed, it would be a good idea, after you have now reviewed the, objections, at least on a baseline level, to declare any relationships or any issues that you believe might, prohibit or compromise your ability to sit on this hearing in accordance with the appearance of fairness. How would you like to begin?
Yeah, the only thing that I would reveal is I know a couple people in the room are connected with the Lake Management District formation because I worked for Oroville for so many years. It would be hard not to get to know those folks, but no personal relationships.
We'll get the remedy at this point, if in fact there's anybody present that would call to question your ability to sit in an impartial capacity. Now is their opportunity to make that objection.
Does anybody object to me sitting on the board? Okay. Thank you. Because that would necessitate the doctrine and the necessity if it didn't, if I couldn't sit here because we wouldn't have a quorum, unfortunately, so.
That would actually be the case, yes indeed.
I have no relations, nor do I know anybody, personally, can meet with the objections.
I would still pose the same question in terms of whether anybody present would have an objection.
Anybody object to Commissioner Hofer sitting on the board in this decision?
Very good. Commissioners, my list is in no particular order. The first one that I have on top is the objection filed by Diane Hartwick. And I believe that's the display on the board as we speak. So the parcel in question does border the lake, was part of the inclusion in terms of the Lake Management District that went out for public review, subject to the public hearings, was part of the special assessment rule. You'll note that they have the written objection on file. I don't know if the party is present to give testimony or not.
Not listed on the sign sheet, don't recognize any of the audience.
Very good. Any questions?
Actually, did you want to have that comment in front of you? If you do, I'll wait.
I actually looked at it, but I was into.
Did you pass it?
Yes.
On your table are the
Yeah,
maps and then the individual complaints as well. And that should be the first one on the list.
We didn't tell you what comes above. Then
We have all the comments that were submitted.
All the objections.
Got everybody. Yeah, we got it.
There are, kind of
Just one.
parsed throughout our emails, so it would be helpful if we had just had the packet of all of them in one place.
We can go ahead and make those for you.
Yeah, I have her comment up right now. I was thrown off by the name.
I mean, the cut and thrust of the objection is, Jenny Reed with the Lake Management District in its entirety. She has concerns that she doesn't use the lake, therefore she questions the benefit that she would receive. I remind the commissioners back during the public hearing process, the criteria you employed was that it be waterfront property. The idea being that by cleaning up the lake, improving the quality of the lake water, bestowed, if you will, an increase in value to its parcels, or at any rate, bestowed a benefit from being included in the district. One of the criteria you employed was whether it was in agriculture and undeveloped. In this case, there's residential structure on the property. So obviously the property is developable, it's not agriculture at this time. So it met the criteria you employ for determining whether a property should be included in the Lake Management District.
And on these, are these all separate motions to either grant or deny?
That would be my suggestion, and each one is an individual objection that's been filed, each one with its own review standards, if you will, depending upon the nature of the objection. So certainly an individual decision, I think, would be in order.
This has a residential structure on it. My feeling is that it will be served by doing this cleanup. So I would move to deny the objection.
Second motion discussion. Just one thing that kind of might help set the stage a bit for this is that if, kind of like, look at this a little bit like a variance criteria. You know, I mean, the fact is how is it different than any other property that is actually in the district? So if someone objects, one point I'm going to make is, if it's not unlike they're forced to pay the assessment, then I'm not likely to then let them out of it in essence, because there's not a huge difference being stated on this complaint or this objection. That's okay.
No comments from me.
With there being no further discussion, all in favor say aye.
Aye.
Aye. Opposed, same sign. So let's move to.
Very good, let me go see how. You go make comments for public hearing.
Just gonna give us time to find out the comment.
So the next one then, Commissioners, Robert Hope. I'll have Angie bring up the map here. You've already gone through your declarations, given anybody an opportunity.
Sheet. And Mr. Hogan, the room.
Very good. In broad strokes, the objection is that, questions essentially the feasibility of the Lake Management District accomplishing that which it intends to accomplish. A number of questions in terms of other funding that may be available. Essentially refers to it as a 5-year experiment. Fixed income's ability to pay came into it, although there's no information that I see geared towards determining whether the applicant, or rather appellant, I should say, is below the poverty line or other issues in terms of ability to pay. You'll note the parcel again is on the lakefront. Meets the criteria as you identified them in your previous hearing process.
So in funding being available, I think I saw that in another sheet as well, objection sheet. And it seems to me that the contribution, in fact, is by the landowners is helpful in securing additional dollars for milfoil control. But the objector points out that there's grant programs out there available. I think that the county advantage of the grant program at the ones. And so I don't think it's not an ongoing program. And I think that's the concern of those that propose the district.
The testimony during the different hearings you had regarding the formation of Lake Management District was there was no ongoing funding available. There may be grants that come and go, and certainly there was no testimony to that effect. The idea was by forming the Lake Management District, you set up a defined revenue stream, so you could essentially operate an ongoing program. Certainly, one of the things that the formation of the Lake Management District has accomplished is that the Lake Management District itself can apply for other grant funding as it becomes available, if it becomes available. Certainly, the assessments being charged could be used as match. There's a number of different advantages that the commissioners identified in your deliberation for the formation of the district. Part of it was to have an ongoing funding stream.
Does this property have a residential structure on it?
Do you have that information on that?
Yes.
Those properties that we have.
So, I move to deny the objection. This has a residential structure on it, and, again, I feel that the eradication of MILFA would keep their property values higher.
Yeah, we have that from the majority of the voters of the lake, and just add that if, the more they pull out, the more it costs for the others that they have stayed in. So just a major point. But if there's no further discussion, all fair to that?
Aye.
Motion passed. So I'm happy.
The next one I have in front of me, commissioners, is Kirkland. And I don't know if the party is present.
Not on the list is, it was Miss Kerfoot. I'm not mistaken. Present in the room? No? Okay. Party not present.
The objection, for the most part, is a question as to whether or not the program will really work.
I'm sure the Mosner's here and would like to testify.
Okay, I'll let them present their objection.
Don't feel bashful about coming up here and talking in the microphone or. State your name and your address, and would you pull that microphone over there for the
I'm Shirley Mulger, and I am, my address is 64B Boundary Point Road. And I have been at this residence.
Wait a minute.
Oh, excuse me.
So in the process of a quasi judicial hearing, it sounds a little official, but it is, requires a swearing in, like you're in court. And quasi judicial means, by the way, it's like a court, but it's not a court, so that's how come you swear to go through. Kind of a formality.
Shirley, would you please raise your right hand and state your name for the record?
Shirley M. Mulger.
Do you, who will be testifying today, swear to tell the truth under penalty of perjury, so help you God?
Yes.
Thank you very much.
I believe that. Thank you, Shirley. You can go ahead now and testify. Yep, go ahead.
To go ahead.
Yeah.
Yes, go ahead.
Really?
Okay, for 53 years, we have been at this residence, and we pay tax on 3 parcels. Where those parcels are, I mean, I don't know where the division is, but it's 5, 6, and 7. And, each one goes down to the lake. And so I am asking if those can be combined into, one parcel for this purpose.
Consolidation of parcels. Do you have, does the buildings cover all three lots?
I don't know where the lots begin and end.
Oh, okay. Well, that picture is kind of showing it, except there's a yellow, there you go. Those three are yours. Do you have one single family residence on there?
One single family, yes.
Did you want to speak to that, Perry? You look like you're leaning forward.
For your record, Perry Huston, Director of Planning, Okanagan County. Just to make sure, I understand the request, but the actual approach, rather than consolidating the parcels, would be segregating the assessment. If the commissioners believe, and you'll actually see another circumstance later, where the parcel started out as one and ended up as 8. So the treasurer's office has been clear, and by statute, you can't remove anybody from the district at this point. But you do have the option of reducing assessments, and one of the things, although it isn't necessarily restricted to this proceeding, you can hear a request for segregation of the assessment at any time the circumstances change. So as you go through and consider any of these requests, if you have multiple parcels, it wouldn't be a question of making 3 parcels one in terms of the role. It'd be a question of dividing the assessment by 3 or 5 or whatever you're doing. So that way, the actual list of parcels in the roll remains the same. And then the assessment is what's subject to adjustment as you're receiving today.
That simplifies the matter. I did, just a question and a comment about consolidation is that, is it not beneficial to the county to have parcels that are utilized as one lot, consolidated?
That's always been, and I'll let the assessor-elect speak to that if you'd like to. In past, I know there's from time to time been a desire on the part of the assessor's office to take the different parcels that have been split out but are actually being used in property to consolidate those under a single parcel number. Now, we have actually in the planning department simplified the process for parcel consolidation, kind of in keeping with that same objective. People wish to consolidate their parcels to a certain camp. In terms of whether it's beneficial to the county or not, I suppose it's a mixed bag. Your valuation obviously changes, which ripples through the total valuation that then dictates the levy based upon your collection. But certainly from a bookkeeping perspective, again, I'll afford the assessor-elect the opportunity to weigh into this if you'd like to, but it does reduce the number of numbers that you have to deal with.
Yeah, I was just, I had asked that question because is removing 2 of them from the, and that's what you're suggesting, removing them from the rolls because that's what the statute says we can do.
We cannot do that, no.
No, say that what I would suggest, and in fact, I don't believe you can actually eliminate a parcel from the roll. You've already established that.
But you can
But you could,
remove the assessment.
let's use this as an example. If you believe because the parcels are reduced frontage, the way they're being used, that there actually isn't, in effect, 3 parcels that will benefit, then you can take the assessment, segregated, divided by 3. So each of these parcels would still get a notice, but instead of the $160, they each get, however you wish to set it up. One could get an assessment of $80 and the other $240 or something like that.
Well, and part of the reason that I asked that question, of course, is because if somebody has parcels in a row and they're built on those parcels, then the chance or the opportunity to sell one of the parcels in the future is not there really. So just that's why I asked that question. So did you have any comments you might want to add to that, Larry? It's okay. You have to get sworn in to do that. Might as well, you're gonna get sworn in.
I have some questions.
Okay.
record.
Larry Yeoman.
Do you who will be testifying today swear all the testimony given in this hearing will be the truth under penalty of perjury, so help you God?
I do.
Are you the assessor-elect now? On these three parcels with one house built over top of it, how is that, how did that happen? How is something like that happen?
Well, the assessor's office, we don't create lots, we just value what's there, but somewhere along the way, somebody, the original survey plans, and this one, I would say original surveys, when, building requirements were lesser. In other words, you didn't have to have a full acre to put a septic system and water and everything on there, they made smaller lots. Today, the feasibility to be able to build on those other lots, if you could squeeze a home in there, is probably negligent. I don't think you could.
So physically impossible if you're to divide those.
I mean, you have to go through building and planning, we don't say yes or no, but Perry can definitely state that probably not gonna be able to build if there's room to put it in there entirely. So these become problematic for us to assess because there's one lot that are being validate through planning in our office in the Vermont that shows. And, but going forward, it is what it is until a request by the landowners is to consolidate.
Well, it appears that we can remedy the situation without that, but I think the other reason why lots get like that is sometimes people just want more, bigger lots, so they'll buy all
Well,
three lots.
It's the way of the world. The best way to create value in the real estate world is to divide a piece of property. Take one and make two, both are sellable. That's all. Unless you have other questions.
I don't have any more questions. Do you? Thanks, Larry.
I would move to grant the objection. These are three different parcels. This would be an objection on three parcels. So is that a motion to grant the objection? Is that three motions to grant objections and reduce?
For the record, Perry Huston, Director of Planning, I don't believe that would be necessary, Commissioner, but if the outcome commissioners are looking to achieve is for these three parcels to pay $160, I might suggest that you'll segregate your payment. A logical way to approach it would be the far right parcel, and I don't have the number immediately in front of me, but the far right parcel, if you assessed it at $80 and $40 each for the other two, it keeps you rolling back and gets you where you wish to
Could
go.
you get the parcel numbers for me, please?
And then one other thought that I'm having as we're going along here is that I'm not sure that this, the hearing allows for testimony by anybody else that wants to comment on the proposals.
The approach I would take, Mr. Chairman, is if somebody wishes to call somebody as a witness to provide corroborative or supportive information, I think they could do that. In terms of just a general opportunity for anyone to speak, that's not the.
I think the main purpose for my question on that would be is that if there's anything that we as county commissioners, not having had a lake management district structured like this at all, that there'd be comments by somebody else that actually help form the district, other people that are paying into the district, might be allowed to make comments.
Of course, and I think perhaps just to some extent there's some confusion. This is not another shot at talking you out of forming the district.
We understand that.
That's all water under the bridge. What we're here today to do is to simply talk about any objections to the special assessment, so.
Okay.
So I would move to grant the objection and reduce the special assessment of parcel number 73000100700 to an amount of $80. Can you flip to the next one? And to parcel number 73000106000 to an amount of $40. And to parcel number 7300105 amount of $40.
I second the motion. Any further discussion? Yeah, so back to what I was, brought up, it's just a question to you, is that, do you feel that that is, the way it should just go, is that if, we make a decision that the rest of the public comes to a public hearing, that we're not given the opportunity to comment on our decision or proposed decision?
No.
Because the change that, it made me think that, and I'm not gonna argue either way, I just wanna put it out there, is that we are doing it one parcel at a time, so it's not one big decision on the end of the public to make comment about it.
Honestly, each one of these are gonna be different. I don't think that there's really, I don't think public input is necessary for me. It's the validity of the complaint. You know, this, obviously, these three parcels can't be built on. Physically, there's one house on them, you would have to destroy the house. And I don't think after hearing testimony, feel you could ever get a permit to build on any one of these other small parcels. Therefore, it is in essence one parcel.
Yeah, I agree with that. So, all in favor, say aye.
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 Thank you.
Easy for you, if you want to get three more thumbs up, but the big problem. We can live with that.
So we're not in testimony or anything right now. I do have a question for you. You stated that if something comes up after this hearing right here in the future, parcel consolidation or something like that, can somebody bring an objection?
As I read, well, it's not an objection at that point. As I read the law, someone can come in and ask you to segregate
Okay.
the assessment at the time of circumstance. Yeah, the law is written around, obviously, the subdivision property. So if you have a single parcel, you come in and split it in four pieces, they could come in and ask you to segregate those four,
Payments.
the payment into the four parcels.
Okay.
They don't have to.
Right.
It's not an automatic thing that they can.
Okay. Very good.
You're golden.
Thank you. That makes sense. I just, in the future, as we go through lots, that are paying for 3 or 4 lots, the opportunity to object is still available.
Well, it'd be, I mean, this is the chance.
Thank you, Mrs. Moore.
This is the chance to object against this year's certification.
Okay.
So, whether or not the law really isn't that clear, right, because of whether, when they think about it more, they could come in.
Exactly.
Your next objection is Sandra Portick. I'm pronouncing that correctly. So this would be your parcel. The nature of, well, I don't know if the party's present.
So, is this not listed, Sandy Horton, not in the room?
In essence, it's the buffer zone. You recall, we had a lot of discussion regarding what has come to be called the buffer zone, which was essentially an agreement that the Knoxville Weed Board and officials in Canada, or at any rate with the Department of Ecology, arrived at to deal with objection filed by, if memory serves correctly, the mayor of the Authortiies. During the testimony, during the hearing process, you recall that the Knoxville Weed Board, specifically the director of the Knoxville Weed Program, believes there are treatments available in that, I believe it was 1,000-foot buffer. They're actually in, as I understand it, because of the changing nature of the application of the chemicals they use, there may be even opportunity to do chemical control in that area, but there are control methods available. So the decision of the commissioners at the time was to not exclude those properties in that again, in that 1,000-foot buffer zone.
Remind me,
So-
that seems to me that had to do with, did you say it was an agreement with the mayor?
Well, there's no document that anyone can lay their hand on that everybody signed. It was essentially as I understand the discussion, it was a self-imposed restriction. And so it was more of an agreement between the Noxious Weed Board and,
Recall, and we did belabor that subject too, but.
so we had no treaty agreement or anything like that we're violating. And you'll recall the testimony was, there really isn't anything that says they can. The objection was, there's some language regarding the treaties about polluting the lake. So it actually begs the question whether this is polluting the lake, but that was part of the discussion. Now you'll recall that one of the things the Noxious Weed Board was very clear on is that the application methods are different. Before it was aerial broadcasting, now it's injection, so you have a much more controlled application of whatever herbicides you use, and the herbicides themselves are different from what they were applying previously. So, anyway, moral of the story, it was the noxious weed, the director of the noxious weed department's testimony that there are, be it mechanical, be it chemical, combination thereof, there are treatment methods that they can employ in that 1,000-foot area.
So I move to deny the objection.
Second motion, discussion?
Yes. So the applicant says they're happy to pay the special assessment if the water in front of my property is treated. And we specifically heard from Anna Lyon, that within the buffer zone, the properties would be treated.
Okay. All in favor, say aye.
Aye.
Next file is Phil Barker. So this is the parcel on the map. I don't know if Ms. Barker's present.
No, he's not.
Okay. Essentially, 2 points made, property, again, too close to the Canadian border. That property too close to the neighbor of Craig Jones' irrigation pump. Both were subjects that were talked about in some detail during the hearing process. We talked about the 1,000-foot buffer, so I'll repeat all of that. In terms of application in the vicinity of these different irrigation pumps, the testimony is that simply a matter of coordinating that. So the application pumps aren't running these, and there's that director of the noxious weed department believes you can work around the irrigation season and still have an effective treatment program.
So I move to deny the objection.
I second motion, any discussion?
Yes. So I know for a fact that Patterson Lake was treated in November, so I know that they treat outside the window of irrigation. And this is within the buffer zone, but the noxious weed board said that they would, in fact, do treatment within that area.
I guess just to add to that is that, that's Craig Jones's pump we're talking about, not Bill Barker's pump, so, to object based on somebody else's pump that didn't, who has property right next door that didn't object, I would say that would be problematic.
That is a lot of problem, I guess.
All in favor, say aye.
Aye.
Aye. Motion denied.
Next file is going.
Going is on the deed for property.
I don't know if the party is present.
No.
Okay. The gist of the objection is, it's not divided equally for all lakefront properties. Object to chemicals being added to the lake, and Canada is not on board with the treatment method. In fact, the assessment, I guess depending on how you define equal, the commissioner chose to do essentially a assessment for a parcel as opposed to based on acreage or frontage or anything of that nature. Nothing in the statement that indicates that the frontage is less or the frontage more, or exactly what the tie is, that would make it not equally applied. And of course, chemicals in the lake, certainly was a subject discussed, again, in some detail during the public hearing process prior to your decision to form the Lake Management District. And certainly there was some who objected at that time. So, go ahead and pull your shading off. Is it developed?
Yeah, it's got a house on it.
Got a house on it. Okay.
I move to deny the objection.
I second the motion, discussion.
The chemicals are being put in there, I know, but again, in the lake near my house, they've asked to put it in and they use that for potable water. So I know that the chemicals that they're using are, safe in the dispersal rates that they're using. I don't know about the Canadians not being on board, that's not really in my purview.
No, the Canadians not being on board is kind of what causes the no-flow problem to be worse down south of the border. And again, that was part of our discussion earlier. And this property is adjacent to city property. The city's paying per parcel too, is what I understand.
I'm sorry, Commissioner?
The city's paying per parcel as well?
Yes, that's correct.
All fair side?
Your next file is Ted and Marjorie Appleton. The objection is actually against the formation of the Lake Management District. They have concerns about the use of herbicides. Their concern was that the waterfront landowners are being asked to do this as opposed to the public at large, or a larger, if you will, segment of lake users. There was nothing necessarily offered in terms of that parcel or lack of benefit, other than certainly a question of the effectiveness of the program itself. Again, I don't know if the applicant is there.
I don't think the applicant's not listed in the room.
Are there are residential structures on both parcels?
Yep, DOR code 11.
And they're not right. Okay. I would move to deny the objection.
Second motion, any further discussion? All in favor, say aye.
Aye.
And I believe your last file, Commissioner, is Irene Thorne.
So I have, just out of curiosity, I have one that says unlabeled parcels and one that says.
And, well, those aren't objections per se, we just want the commissioners to be aware of it, because it will involve an amendment to your special assessment. So I don't know if this part is further.
Pardon?
I don't know if this part is further.
I don't think so. I just asked and I didn't get a response, and she's not on the list of this.
Again, it's as much an objection against forming the district. There was some concern about holding the meeting at this time of year. The timing of the statute, the special assessment role was certified at the end of the year, and this is the opportunity to object to that. So there's nothing actually that you could do about that. That is handed to you by state law. The rest is, again, question in terms of the efficiency of the program, additional taxes. Nothing that was offered about this parcel or any issues with the assessment, other than the objective was essentially the formation of the district.
Move to deny the objection.
Second motion, any further discussion? All in favor, say aye.
The other files or maps, I should say, Commissioner, that you directed our attention to, let's go this one.
The unlabeled parcel.
Okay. These are City of Oroville parcels. The City of Oroville, some of their parcels were identified by parcel number, others were not. They were labeled as park, in one case is waterfront. So, according to the treasurer, each of the parcels on the special assessment roll has to have a parcel. So working with the assessor's office or now the parcel. We actually have numbers, the treasurer's office will obtain them. So, essentially a direction by the commissioners to add the parcel numbers for those 3 City of Oroville lots to the special assessment roll.
These were never added to the special assessment.
The
roll.
parcels are on the roll, they're just not.
Oh,
identified.
just the numbers were not on the roll?
Correct.
Okay.
So we're just adding those numbers.
I would ask the,
We
could
created,
you come up and?
Yep.
you stay sitting up with this one. Larry Dillon for the record. We established the 3 new parcel numbers, one that weren't just the way things are created, they were just exempt parcels, hadn't been created with parcel number. We created the 3 parcels, but created them for the roll year 2020. We cannot make changes to the 2019 record until taxes go up. We can add them back, establish them for 2019. We have the parcel numbers, but for our roll purposes, we're finishing the levies for the year. We cannot effectively make any changes to the 2019 record. But we do have the parcel numbers. And as soon as, we're done with the levy process and the treasurer mails the taxes, then we go back and make corrections for the 2019 for this project.
So would this then, a motion to add these, or is it just a motion to change these parcels to the corrected parcel numbers?
I would suggest a motion amending the special assessment roll to add the parcel numbers to these 3 parcels as directed by the assessor's office in Gaylord,
When possible.
when possible.
We'll have those numbers as soon as we can reopen the books.
Okay. So I would move to add the parcel numbers to the Lake Management District roll as directed by the assessor's office when possible.
I second the motion, discussion, just add a little information, I guess, is that those are both parks, mostly parks, and,
Well, there's 3 parcels, so it's, Deep Bay Park, okay, and then you come down in the city, the lower one of the 2 was the park, and the other one is just shoreline that the,
and Shady Park was part of the subdivision, and it was like dedicated as, I don't even know if they had it.
and the law doesn't say we have to create a parcel number for all exempt properties, so it was just never created.
Right.
But there's no law stopping us from creating a parcel number, and lots of them do, so we just created a
Okay.
parcel number for you.
And, yeah, then when, there's also kind of a boulevard in that other one, part of the subdivision, so.
Yeah.
Okay. All fair side? Aye. Thanks, Larry.
Yeah, then the Thorndike property. When the ballot went out, this was 1 parcel. After the ballot went out, the subdivision was approved. So we went from 1 parcel to the 8 that you see here. I have not been able to talk to Mr. Thorndike at this point, so on your assessment roll is the retired parcel number. So that parcel number is in effect gone away, and now you have 8 new parcel numbers in its place. So,
Can we add to the roll?
we're not adding property to the rolls. What you would be doing, and this will come about if any other parcels subdivide, because then the original parent number generally goes away, and then you have new numbers assigned to them. So, and I'll defer to Mr. Gilman if he has a better idea. I would suggest that you add the new parcel numbers. You're not adding property, you're adding the new parcel numbers to the assessment roll. we can give Mr. Thorndike, because it isn't tied to this hearing, you can ask for segregation at any time the circumstances change. Leave it to him, whether he chooses to come in and ask to have that segregated amongst the parcels, or he can just leave it as it is, and the new owner will be subject to the assessment.
So, as of right now, that's getting $160 assessment.
Correct. Except the parcel number is no longer valid.
Except for the parcel number is no longer valid. So, if we add the 8 parcel numbers to the roll, which we can do,
You're adding parcel numbers, not adding property.
understand that, adding parcel numbers to the roll, does each parcel number then get a $160 assessment?
Well, that's my interpretation unless somebody asks for it to be segregated. Observations?
Well, on the tax side, so we have a unique situation where it can't be built on. In this situation, Mr. Thorndike's subdividing to sell, I would say in the proper equal world, each one should be attributed the full value.
And all of these obviously are buildable because you just did the,
Just met all today's current segregation requirements.
so, do we have parcel numbers for them yet?
Yes.
I don't know that we have that.
Yeah.
We have that list, okay. Go ahead and bring them up.
Is it right now? Okay, so this is gonna be a motion that is gonna take a little bit to do because you're gonna have to go through these all. So I would move to add parcel numbers 54900000100.
You go through to a number consecutively.
Yes, they do.
You go to the end of it.
54900002000. 54900000300. 54900000400. 54900000500. 54900000600. 54900000700. And 54900000800 to the Lake Management District Rural.
I did. Second motion. All in favor?
Aye.
Commissioners, those are the files and the questions, if you will, we have for you today. If the commissioners are satisfied with the special assessment role as you have now evaluated it, I would suggest the staff be directed to prepare a resolution certifying the special assessment.
So I would move to have staff certify, create the special assessment role.
It'd be certified.
Certified for special assessment.
Second motion. Any discussion? All in favor, say aye.
Aye.
That is your business for this public hearing, Commissioner.
Thank you. We will now close the hearing.
Moving into the rest of your study session agenda, Commissioners. RIA 49 on your appointment letters and the planning unit membership. The RFQ is out. The deadline for submittals is the 28th of December. I have already alerted the planning unit members, proposed planning unit members, I guess at this point, that they will be asked to review the submittals, then make recommendations to you. So that's on their agenda for the January meeting. The first Thursday, I believe, is where we arrived at the next meeting of the planning unit. terms of the grant, Vanessa's still looking at the application to see what, if anything, we need to polish up. So I don't have any update for you on that. But kind of rolling into the WRIA 49 discussion, I wanted to go over with the commissioners how we're administering the permit exempt well process in WRIA 49. And I realize we've talked about this before, and we've actually some questions at the Department of Ecology, but there's still perhaps some answers it would be useful to have. In accordance with the legislation, ESSB 6091, if a person wants a building permit, they have a well. Their well provided was constructed. Their well, so that's the only evaluation that we do. They have a well log. They want their building permit to have public health and the building department still look at how much it produces and water quality and those sorts of things for normal. But in terms of what we do, that's the proof of potable water, that's the review. We don't charge them the $500, as I read of the legislation, those were all essentially grandfathered. They do not have a well. They pay us the $500, we review where it is, what it is, if there are any other issues, and in 49 that there aren't any closed basins or anything like that, specifically identified, in which you just can't get a well. Now we're talking building permits at this point, so the water availability study area overlay would impact that. And we record the 3,000 gallon a day restriction against their title. So that's the process in 49 if they do not have a well in place. Now,
I got one quick question. So are we using the database that Gene kind of set up? Are they're going in there and
those are feeding in.
those are feeding into there? So at any one point in time, he could run a report and tell you how many wells with that 3,000 gallon restriction.
Should be able to.
Good.
Should be able to.
Okay.
We can pull it through his report, or we can pull it through our rec tracking system.
Okay.
Now, subdivision of land gets a little more interesting. So, some argue that when you subdivide the land, let's harken back to Campbell Gwynn, the 2002 ruling that creates 5,000 gallons a day per project. So if a person came in with 20 acres or 2,000 acres to split into 4 lots, we would divide that 5,000 gallons a day amongst those lots. That's the way we've been administering it for quite some time now. However, some are arguing that that's not what the legislation says. That if you subdivide the property, then each parcel, you would record the 3,000 gallon a day restriction against the title. I'm not convinced that's what they intended, but there are some who believe that that was the outcome. So,
I don't know how their legislation would change corporally.
pardon?
Well, or the 1945 groundwater rule that says any group domestic or group domestic use has a 5,000 gallon a day withdrawal maximum.
Well, that was that 9044-050 language in the RCW. That was the interpretation in the Attorney General's opinion 9806, 9606, it escapes me now. Then of course the Campbell Gwynn decision in 2002. They didn't necessarily define with specificity what a project was, and that's been a little bit of a hiccup over the years, whether 1,000 acres or 10, is it all still a project? Well, the Department of Ecology has in the past essentially argued yes. We still have your challenges with exempt say.
They really haven't said yes. They have to look at it on, does it meet the requirements of a project? That's the weird part.
Well, that varies actually. We have letters in our different files where they have actually tried to reach back in time. Just some of the old land division proposals, and then someone wants to do a subsequent division on a parcel within that, they've actually tried, we've never come under appeal, but they've actually tried to go back in time, split up the 5,000 gallon bin and split up whatever that parcel would have had. So it's been a little bit of a mixed bag in terms of how they work that. Now,
So, but let me look at it this way. If I got 1,000 acres and I split it into 50 20-acre parcels, and that's all I'm gonna do, 50 20-acre parcels, and I'm gonna say that it is the responsibility of whoever buys these parcels to get water, however they're gonna get it. I'm not gonna sell it with a condition on water or anything like that. No.
well, that was essentially the argument that the applicant made in Camp Gwynn. What some would argue tripped that up was he actually wanted to drill wells.
He applied for
So
it.
he did, or was going to construct the means to withdraw water.
Right. He was one individual applying for a groundwater withdrawal split over a whole bunch of parcels.
But there has been some effort on the part of the Department of Ecology to impose Campbell Gwynn even on their large lot subdivisions. Now, we ran, it was threat of appeal, but never went to litigation. Well, no, it was actually appealed, but it never went to court, I'll say it that way. That application was withdrawn. In 58-17-040, as I recall, there are actually exemptions to the requirements of the chapter. In 58-17-110 is where you find the requirements, the criteria that you have to apply before you or I, as an extension of you, can approve a subdivision proposal, part of which is, of course, adequate revision for potable water. In 040 are exemptions to those requirements. Now, the cases have gone into some belly about all the time. The court rulings have never reached back into the exemptions to say if those are still on the books or not. I mean, they're obviously on the books, they've never been repealed, or whether they're applicable or not. What we do, because there is no categorical exemption for large lot subdivisions that go beyond 4 parcels. If someone comes in with a large lot subdivision application, they're exempt from the requirements of 15-17. Your own code is a very relaxed process for that, but we still make them go through SEPA because there's no categorical exclusion. If they do 4 lots or less, while there isn't a categorical exclusion for large lot segregation, there is for short plats. So we're applying essentially that exemption for 4 lots or less large lot segregation. So the question of water doesn't come up at that point. Now, we haven't had any pushback for the small exempt set proposals, although one did, you recall, come under appeal. We've gone through SEPA on some of the large lots, but we didn't actually allocate the 5,000 gallons a day. So it's a mixed bag in terms of what we do with the large lot proposals. The smaller ones, you'll recall, Commissioner, back 09, 2010, thereabouts, we were actually putting water allocation tables on the face of the plans. And then we ran afoul, or thought we ran afoul of then Attorney General McKenna's ruling that you couldn't amend 9044-050 through rule or local decision making, and then we stopped doing that, but we still applied Campbell Gwynn. So now, in terms of 49. Some who suggest all of that only applies to domestic well use, in-house residential stuff. They claim it's silent in terms of commercial use of the permit exempt well. Creates a whole nother discussion because we are authorized to repair and stream flow during the time period that we do the updates to the watershed plan, and then we follow whatever those updates dictate. If we're going to argue that the bill only applies to domestic well use, then I guess we would have to, by extension, apply, or not apply, would be a better way to say it, that authority to impair and stream flow to commercial wells. So we have actually, I have not made that distinction in terms of how we administer it. Be it a commercial well or be it a domestic well. We're still applying 60 minutes, and Campbell Gwynn and everything.
Yeah, and by commercial well, you're talking about an exempt withdrawal, but under the commercial,
industrial use.
industrial, or
Right,
commercial
see, and
garden use.
we actually have a number of those. A lot of your marijuana farms are on permitted exempt, well, not all, some are in irrigation districts, but some are on.
Nursery.
Say, the one nursery, discussion that came up the other day. Although that arguably is a use that's been in place for a long time, but certainly the review will be triggered to.
Well, it was the question was whether or not that parcel was subdivided, is whether or not it would affect the commercial well, or commercial use, and, you know, for, domestic use on the same property after it was subdivided.
Now, we've been applying Campbell Gwen for even the commercial uses. So for instance, in the last year, now this year, it's gone out for public review of your marijuana regulation. Our calculations based upon the paper DOE has produced would restrict your marijuana grow to something just short 30,500, right? But something just short of 40,000 square feet canopy on one permit exempt withdrawal. It will be on the 5,000 gallon a day restriction. Now, the reason I bring all this up is just to kind of remind the commissioners that we're doing this, obviously. Would ask if you see challenges in what we're doing. And we still do kind of have the outstanding question. If you subdivide, am I splitting up 5,000 gallons a day? Or am I splitting up 3,000 gallons a day? Or does each parcel get
Or
3,000
getting a new
gallons?
lot, yeah, a new lot with a new, privilege to drill a well and use the allocated amount per lot.
Okay. What we're doing now is applying the Campbell Gwen. We're splitting up the 5,000. So if, by way of example, if you have a parcel you're splitting in half, rather than recording a 3,000 gallon a day restriction, we're actually going to record a 2,500 gallon a day restriction. If it's a new well, we still pay the $500 that the law prescribes. Input, observations?
I'm reading through 6091.
If you, prior to this decision, I would say if you had a well, I don't know, this property, you can subdivide the property in 49 short plat, and that 5,000 gallon exemption applied to the property already, then you would be splitting it into 25 and not restricting it to just domestic indoor use. Is
We
that-
haven't been restricting it in terms of indoor use or anything like that. And I don't know that we don't believe we have, actually. Where we found most of the water allocation tables were short. Many times taking a 20 and popping it into 4 or 5. Have the 1,250 gallons a day. I believe we did have, not so long ago, proposed to subdivide one of those. And we actually split the 1,250 between the two parcels, because it was relatively close in time. Still beyond 5 years, because you're restricted any further subdivision in your short plat, if you've done 4 lots for 5 years. So, now, at some point, and we back in the day, if you will, we were using gallons a day as the minimum requirement for your domestic use. So that would get you up to 14 connections on permit exempt withdrawal. State Department of Health was applying the second half of the Group B definition using census data, 1.8 average people per household in Okanam County, and actually coming up with only 11 that would be put out because of the water use, but because of the second part of the definition, the Group B system, I can't recite it now, 25 people over a period of time, et cetera.
So, there's a couple things in here that I'm reading that I just kind of want to point out that I actually hadn't written for. So it says, within counties not required or not choosing to plan to pursuant to RCW 3670A040,
Growth Management.
Growth Management Act. The County and the state may mutually determine those areas in the county in which the requirement of subsection 1, which is,
And you're in 1927-097?
I'm in, well, I'm reading out of ESSB 6091, which is changing the,
The 6091, that sounds like language that was in 1927-097, the building permit code, the section 2.
so it's in section 101, RCW 1927-097, yep, and 2015, 20, So each applicant for a building permit of a building necessitating potable water shall provide evidence of an adequate water supply for the intended use of the building. Okay, so it says if we're not planning under the Growth Management Act, that we can actually go to the state and say, hey, there's might be some areas where we don't need to do this.
Yes, no, that's correct. And when we,
Okay.
you might recall, Commissioner, that came up during what became called the omnibus hearings, back when we were building the record on all this, in terms of whether in 48 in particular, because you had the 2 CFS reserve, we were working on our tracking system to determine how much water was available. DOE was beginning to try to get started, but they were beginning to talk about working on the closed basin maps. If in fact, as a result of that work, if we couldn't just essentially pre-identify areas where essentially we determined there's potable water available.
Buildings that do not need potable water facilities are exempt from the provisions of this section.
Correct. And then one of the amendment in 6091, as I recall, and I may be incorrect here, but the amendment that essentially created the opportunity for the presentation of a well log as proof of potable water, I believe, was an amendment in 1927, 1927, sub 2.
But section 4 was never crossed out. So there was a section 5 added. It says any permit exempt groundwater withdrawal authorized in 9044-050 associated with a water well constructed in accordance with the provisions of chapter 18.104 RCW. Before the effective date of this section is deemed to be evidence of adequate water supply under this section. So they're saying that anything prior is grandfathered in, but any building that doesn't need potable water are exempt.
So now we're applying that amendment in 49. You'll recall we had a discussion whether that was also applicable in 48.
Well, no, let's just deal with 49, because that's what we're talking about.
Fair enough. We'll hold that thought.
I will.
We're still wrestling with that one just a bit. But the 49, as I'm administering that language, comes in on a building permit, the well is in the ground, they have a well log, it's lawfully constructed, we're just accepting that as proof of potable water. We're not charging them the $500, we're not restricting the top.
So the city, town, or county legislative body shall inquire into the public use and interest proposed to be served by the establishment of the subdivision and dedication. Shall determine if appropriate provisions are made for, but not limited to, the public health, safety, and general welfare for open spaces, drainages, streets, roads, alleys. See, that was a section, that's a new section 103, that section's in there already. What we got? Two. So new section 202, which applies to 49.
Correct.
Unless requirements are otherwise specified in the applicable rules adopted under this chapter or under 9022 or 9454, potential impacts on closed water body and potential impairment to in-stream flow are authorized for new domestic groundwater withdrawals exempt for permitting under RCW 9044-050 through compliance with the requirements established in this section. Following water resource inventory areas with in-stream flow adopted. See, and actually it is talking about domestic water use specifically.
No. I think I think it gives rise to the question whether a new well in 49 for commercial uses, at best it'd be interruptible.
But it says that, if you go up here and read the section though, it says that buildings that do not need potable water facilities are exempt from the provisions of this section.
That's, say, with specific regards to 1927 and 97. I think you have 49, where we are from time to time below the stream flow levels. If there's new water, if you will, appropriate. Well, the legislature has now told us you can go ahead and impair stream flow for domestic use. But they didn't say for anything else. So, whether, and where it actually comes up most often is just the marijuana farms. And actually, most, not all, most of the farms in 49 are on some kind of irrigation system. So all that discussion is moot for them. But for the ones who are not, I think it does beg the question of during times where below stream flow, if their water source isn't interruptible.
Right.
We've actually had that discussion during one conditional use permit process, and they were in fact required to put in storage, so they could irrigate during times of below the stream flow. We haven't reached back in time with any of the ones that came in during the time period when we weren't regulating marijuana with any specificity. Now, I assume, I don't know obviously, because I'd be predicting the future, but I assume that discussion will be part of the WRIA 49 planning unit's work as they do the updates. Part of the water budget or projected water demand, I would assume, should include not only domestic uses as well. So whether that'll be dealt with in the update or not, I suppose remains to be seen.
You know, maybe they just figure you're exempt because you can be shut off and it's not life-threatening.
But I mean, we've had circumstances, again, the wedding venue and the one CUP we processed with, in 49, we have introduced the question of interruptibility as a condition, so. Anyway, again, I just wanted to kind of walk the commissioners through how we're doing it, see if any red flags went up. Obviously, it'd be useful to know that the commissioners aren't comfortable with the approach we're taking.
So isn't it? It's 3,000 gallons per day instantaneous, 5,000 gallons per day.
Annual average.
Oh, no, other way around. Otherwise you couldn't have.
Right.
Yeah.
5,000
It's
gallons.
5,000 gallons per day instantaneous with a 3,000 gallon per day average.
Right. Right.
So. And how are you basing? So we're splitting it up if it's a project. How are we determining whether it's a project or not?
At this point, we're using a demonstration of physical and functional relationship. So obviously, the one owner, one parcel, they're splitting it out and define that as a project. We look back in time a little ways to see if that owner had already done some subdivision activity that we need to look at if that 5,000 gallon has already been allocated once, so we're reallocating a piece of that. I have never employed what the court kind of introduced in something of a chatty basis, saying general vicinity, those sorts of things. We generally don't reach beyond an individual owner unless there's some relationship with the owner. It's an LLC or family splitting that property or something like that. Then we'll expand the boundary of project to include that. We haven't had a lot for a number of years now, any large number of parcels proposed in recent history. Where most of the subdivision activity that has gone beyond the 1 or 2 or 4 lots has been up on the soils where they're in the city's water system. Or we've had some others that were actually in water systems. Now, we're still allowing group systems in 49. Shared one, I suppose is a better way to say it. Which of course we strayed away from in 48, so. It's subject to change, obviously. But in 49, we haven't applied that restriction.
No, we shouldn't, because there is no restriction.
Right, absolutely.
The less holes you put in the ground, the better it is for the environment.
Well, it makes sense that if you're gonna apply, you know, in every subdivision, you're gonna be dividing up the exemption opportunity. It makes sense because then why would you put more holes in?
Exactly. Fully agree with you.
And it's more efficient actually.
Yep. Agree with you there also.
Because that's, you know, I always recall seeing the end around on that particular subject where you saw 4 wells all in a row. And they were all on the same parcel just to serve the other parcels, which is pretty ridiculous. just to, you know, satisfy a rule.
Here's an interesting thought. So when the 48 was written back in 1976, it was a surface water rule. That's what basically. I posed the question, how would anybody off of the riverbank ever be able to get water?
That's been something of a debate.
Okay, so then I pose the question, okay, so what you're saying is that this was a surface water allocation and anybody can go and put a pump in the river. So if I have property, I could go and put a pump in the river. I could withdraw water into the 2 CFS reservation, and then I could actually go and apply for the certificate that says that I'm doing so. So then, if I went and did that, could I change my point of diversion?
All interesting questions, Commissioner. We have, in my humble opinion, we've kind of leapt over
Way left over.
the question. The only mention of groundwater, other than a 173-548-050 for the closed streams and lakes, any groundwater and hydraulic continuity is closed too. The other mention of groundwater in the Met-Al rule is that if the groundwater is found to be in hydraulic continuity, and if the groundwater withdrawal, I believe the term is measurably, might say significantly, I think it's measurably, impacts surface flow, then the rule applies to groundwater as well. Over the years, I think we've just kind of fallen into an acceptance that, yeah, I must apply to groundwater too, because we've essentially taken the 2, as you point out, the 2 CFS reserves surface water in each of 14 regions, where we just kind of scratched out surface water, scratched out surface and put in water. So now it's surface water, groundwater, commingled, all the above. That's what we have to work with.
Yeah, see, back then, in 1976, they knew that permanent exempt wells existed.
That was adopted in 1945.
Right. Well, so wells were not counted into the 2 CFS reservation.
No, that's surface water.
It was all surface water. So back then, they actually said, okay, we're reserving 14 CFS for these uses, the listed uses, but we also know the wells are going to be going off.
One could make that interpretation. and always leads to a lively discussion
Well,
in certain venues.
you'd certainly be looking back to legislative intent in the conversation that went on when that was being developed. Um, Just off the top of my head, I'm inclined to think that everybody knew what they were talking about in that regard.
They didn't know what they were talking about. They didn't want to, I mean, you look at it, they talk about wells. They
Yeah,
talk about
yeah.
groundwater wells, and that there's enough groundwater to supply the Mountain Valley for years to come.
So the TCFS was ignorant of, groundwater, withdrawal connection or continuity,
Correct.
interaction with the streets?
In 1976 it was. In 1991 was when they amended it
Yeah.
to say that groundwater, but so back then, you had these two CFS reservations that were, hey, you can go throw a pump in the river and pump out of it as a circuit.
So the TCFS reservation was for domestic use?
Well, it was for, domestic use. It included a half acre of lawn,
Yeah.
single domestic use.
Yeah.
Okay, so that means each individual person can throw a pump in the river. And then they allocated, in-stream flows. And then they went to, public water supply. But it was all based on surface water. It was all based on throwing a pump in the river and actually sucking liquid water out of the river.
It seems almost odd to think that only because there's so many wells that were, developed, hell, many of them drilled in 1945.
There weren't that many.
Dug in 1945. Well, the municipal wells I'm familiar with, there certainly were.
Yep, they were, and they were actually listed in the document.
Because of, so that's saying before 76 or up till 76 or even past 76 that, the predominant domestic use was from the river or stream direct.
Mm-hmm. Yep.
Actually, here's where the conversation, we're really down the weeds here if we want to, but here's where the conversation kind of gets interesting. We are, and rightfully so, I think, have decided that TCFS reserve, each of the 7 reaches, is senior to in-stream flow. Because it was first allocated, and in-stream flow was allocated, and the other water usage. We are single-use domestic and stock water. I was thinking about this here a while back when this debate was raging on yet again. If that's the case, then surface water withdrawn from the reserve would be senior to in-stream flow.
Surface
If it
water
doesn't-
withdrawn from the, yeah, correct.
If
That's
it doesn't apply to groundwater, if we accept for the moment that the wells that have gone in since 76 aren't part of that surface water reserve, it would not have inherited that priority. So
Right.
arguably, your groundwater wells would all be junior to in-stream flow. Now, that's not the way that's why I say we've kind of taken this leap. And I'm not saying that they wouldn't be able to determine that, hydraulic continuity, at least in many places, probably a given, measurably impacting the surface flow. I don't say they can't, I just say they really haven't. No one has actually made that assessment. But if in fact we're talking a separation between surface water and groundwater, then the other side of the coin is your groundwater wells, again,
Would have never had the-
wouldn't inherit that priority. So, that would, the other side of the coin.
Yep. Interesting.
I love water.
Yeah.
I love water.
That's what you live for.
I do. It's been a big part of my life for a long time.
Right.
Commissioners, any observation? I said, I just wanted to walk you through 49 and see if there's any challenges or anything we're doing at this point.
I guess the only one that comes to mind is that, given all that change in the way we treat water, which, you can
Well,
You're
yeah,
laughing, I don't know. if
I,
you're
no, I
laughing.
was laughing because I was thinking, well, yeah, I see how it developed. It was the giant maze that somebody followed and crossed over itself 10 or 12 times. to
Well,
get to where we were.
yeah, and, but a lot can change, and a lot of proposals come in to actually, just like the tax law, to circumvent it. So as time goes on, things just tend to tighten up and interpretations change. And I was just thinking about that in terms of, one molecule of water being connected to a stream and something like that. And as time has gone on and people looked at the water availability differently over time. It's been withdrawn from the west side. There have been impairment issues. I don't know if people filed impairment claims, but there's been impairment issues that it begins to look differently. And so, as tax law did too, I mean, there was not only loopholes in the systems, but there were things that occurred that made people go, it's not that simple anymore, because it was simple back in the early days of water. I'm diverting this much water off a stream. And then as we began to be more mobile and able to drill wells and dig wells, we began to use water in a different way.
Here's the interesting.
Because riparian rights were what started the game.
If we truly go to the molecule for molecule theory,
Right.
we know how much water can be used. Okay, right? I mean, I can say, okay, 14 CFS equates to this much, and we have to allocate this much per household by state level. Okay. So that means I can tell you how many houses could be built in this county.
Mm-hmm.
I should be able to tell you how many houses or how many residents should be able to live in the state.
Mm-hmm.
So
Based
they're-
on water.
Based on water. So maybe they should do the calculation of how much water they have in the state and say, okay, this is how many people can live here. We're at 7.44 million right now.
So, just to get.
This is all that's left.
That'd be going back to riparian rights in a way, because it was simplified and things get complicated. So, give you an example of two Canadian developers that show up with my doorstep in Oroville and say, here's your rules, and here's how we want to use water, and reuse water. And so that changes the way everything looked that we created for rules, if we in fact allow. It changed, it sets back for the water rights and how much we charge for water. Changes the rules, and you have to adapt to that if you want to do it. I'm all for doing it. That's water reuse and water conservation. And so it changed how much water people really would use. So there's a whole bunch of things that are coming in the future that changes things too. And even that idea that we could have cisterns and you could go buy your water from somebody else, as far as improving water adequacy, which changed, people started doing different things. People decided they could live out there and haul water to their cistern, So, I mean, it's adaptive management one way or the other. That's why we change water around all the time. People are doing different things. Now we're pumping water into aquifers out of the Columbia Basin to serve the industrial infrastructure that brought all the people to that town. Otherwise, nobody would live there because it was a damn desert. So there's all these things that are going on that certainly do complicate, how we deal with the availability of the water. Just the thing that came up the other day, I was just thinking about, no new lots in water study areas. Well, the more you think about it, I mean, if you're using the same amount of water, it changes the appearance of that. If you're using the same amount of water for 200 lots that you were going to use for 50 lots, from the water standpoint, it changes the picture. From the growth and development standpoint, that's not why I guess there's an interrelationship between land use and water that is being actually asserted that that's how we're controlling development, is through making water rules. And so we began to sort of bastardize the water rules to control development, and it doesn't, the control of the water doesn't make as much sense anymore. It's focused on controlling development. So.
One could argue if you wish to control development, just control development.
Control, yeah, be upright, yeah, straightforward about it. But, you know, that's where water law's been messed with quite a little bit, just to address the development issue, you know. And it probably not up either. Because, you know, it's like, then you as the decision makers can blame water availability rather than just say, hey, wait, development in this particular area is gonna cost us more and it has not a damn thing to do with water. But it's easier to, and you know, that's the accusation that people make of ecologists. Like ecologists trying to control the river, not trying to control the water availability. That's an observation, it doesn't get us anywhere.
Anything else under the banner of 49, Commissioner? I had, under code enforcement, I actually would prefer to be better prepared to get deeply into that discussion, but what I'm thinking is, we have a new sheriff in town, we have a new prosecutor coming on board. You'll recall that I had initiated a discussion before about bringing all the players together. I got as far as the prosecutor's office and kind of some of the finer points of the code revision I was working on. I'm gonna fire that back up and see what we can do. I still have in my mind, respectful of the commissioner's desire to not create a code enforcement position or something like that. I still think there's some opportunity for building planning to do the baseline intervention, if you will, the notices, trying to get everybody into compliance. And then when we are unsuccessful, involving law enforcement, literally under the banner of their commission. Actually cite people with important assets. So anyway, just wanted you to know that I'm kind of working on that. So.
Yeah, my perspective on it is that to take in, especially in Oakland County, to take and identify somebody as a code enforcement officer, and that's what their job is. I think that that's problematic, and I think that law enforcement should be involved in it. In certain areas, I hate to see that target placed on anybody that is not in a position to actually enforce the law with a gun.
And just to make sure my observations aren't misconstrued, I had a good relationship with the previous sheriff administration, right, suggesting something remarkable has changed.
Right.
We just had fresh set of eyes, you know, and somebody forming their own administrative approach to law enforcement. I've actually had good cooperation in the past. If I needed an order served or something like that from the previous sheriff's administration. So that's not implying that things were bad before, we just now kind of an opportunity, if you will, to pick it all back up.
Right.
And see what we put together in terms of.
Yeah, I think it's a good time to do that. Because the cooperation exists in other jurisdictions, in the cities and towns oftentimes. It's easy to.
City of Ellensburg, Ellensburg Police Department.
Yeah.
Does code enforcement. They're the ones who do the code enforcement stuff.
Well, you know.
There's examples of.
Some of the arrangements tend to be, even if you're doing code enforcement as the planning department, whoever's doing it at a particular time, has cooperation from the law enforcement agency to make sure that's a safe endeavor.
Kittitas County, under the fire marshal's office, which is under planning and community development, which is a combination of planning and building. They have a separate code enforcement division, but it's actually under the fire marshal. They do the code enforcement there. So there's different bodies around. But again, I just wanted you to know I was working on it. I'll keep you posted as we make progress. Under the banner of Oroville EMS, just a reminder, I'm going up to Oroville tomorrow night to the city council meeting. I don't have a presentation. They asked, Lifeline to be there, and in fact, I forwarded to the commissioners the information Mr. Walker prepared for that meeting.
I told the mayor I would come up there.
In terms of response and whatnot, so I'm just more going as a resource, be in the neighborhood.
Yep, that's exactly the reason that I would go.
Very good.
Just to be there to sort of, it's reinforcing also where we're going with all this, and, you know, our relationship with health is important as well.
Which kind of segues into the last item on your agenda is the whole Regional Fire Protection Service Authority. There's some confusion in the newspaper article. I think the comment the reporter made is the fire district may be called upon to take over ambulance service, and that wasn't the
You know,
observation.
it was interesting. I had a conversation with Wayne at the meeting for dispatch, and he mentioned that. And I don't know if it was something that he was saying, well, you have that opportunity or whatever. I'm not sure where that came from.
Well, it came from my conversation with the reporter.
Oh, I see.
I was talking about the Fire Protection Service Authority,
Okay.
perhaps, doing that, not.
Maybe that's where Wayne got the impression that we were having that conversation. I don't know.
No one on any venue that I've been involved in has talked about the fire district taking over.
Okay.
What we did talk about, however, was the overlay of the Regional Fire Protection Service area as another funding option. So I'll make sure we understand what that's all about.
Good.
I haven't gotten a call from any district chiefs yet, which I kind of anticipated, frankly, so.
Yeah. Okay.
But that's what came from that. There's some confusion in terms of the distinction between the fire district
Right.
and the fire protection service authority.
So you're still looking into that?
I am, yes.
Actually, I was thinking. And Dr. Katie as well, you know, we were talking about the trauma areas and how they're different than the, you know, the licensure areas, different than the districts and all that interplaying. I mentioned something like that. She thought it was interesting and not a very interesting idea, just depending on the details. I was thinking about it in terms of financing. Finances amongst the districts.
And it could cover all those areas. I mean, obviously came about the EMS discussion, but they actually have some fairly broad authority in terms of what that plan, I mean, the centerpiece of the plan. The service authority, the committee, the planning committee creates a plan, and then they receive tax funding to implement the plan. So depending on what the plan focuses on, EMS, fire protection, communications for EMS and fire protection, all could certainly be included in that setup.
Right. So on the regional council for EMS, you know, and all that business, they don't have a county representative, and I offered to be on that regional council, and Wayne in fact said there's a position that's open that may very well work for that. I think the counties need to be involved in it.
I was trying to remember how, we chatted the other day, I was trying to remember how it was set up, and I've got a copy of the plan, I should pull it up. I don't believe there's a position for like a county commissioner per se.
No, I think you mentioned something where it fit.
But as I recall, you recall in our discussion, Ben and I actually went to several meetings when we were working on an issue with Tenasky EMS. And actually it was under the banner of the festival for that, that we were working on. And the observation was made that the representative hadn't been going, so. Anyway.
Well, I think it'd behoove us to know about that with 3 districts under us. And, you know, knowing the regional plan is draft is, I think, supposed to be adopted in May.
I don't know.
They have an update, I think they said May, that she said you might wanna look at that plan.
Fine with her.
Yeah.
Commissioners, that's your agenda, anything for me?
Don't have anything.
Very good. I sent you out a proposed lead schedule, which is already changed, so I'll send you out the, so keep track of my work.
You're only taking a day at a time, so, weren't you, a day or two at a time?
Well, I had a grand plan, but then last Friday didn't work out as well as it could.
Oh, right.
And, this Friday, working out as well as we could have, so, oh, which reminds me, Kenneth Thompson, Washington State Groundwater Association, is coming in to chat with me about 48. If you happen to be in the neighborhood.
When is it?
11 o'clock, right?
I'll be here.
Very good, Commissioners.